In the early 1990s, the Bankstown Football Club suffered a series of fires which caused substantial damage to buildings and property. They claimed on their insurance policy with CIC Insurance. CIC refused the claim, and the dispute as to whether the claim should be paid went to litigation. Along the way, CIC decided to terminate the insurance contract. They sent the club a letter to that effect. However, the insurance policy was also coming up to its natural expiry date, and there was a statutory provision in place which required insurers to advise the insured party that their contract was about to expire and whether or not the insurer was prepared to renew the insurance. If the insurer did not advise these things, then there would exist a statutory insurance policy between the parties, essentially equivalent to the previous insurance policy. So the law would maintain the insurance in circumstances where a party had not been told the insurance was due to run out. The idea of this provision was to guard against people inadvertently becoming uninsured because their policy had expired and they had not realised. CIC did not advise the football club that the policy was due to expire, and therefore the football club argued that a statutory policy had come into force. The insurer, on the other hand, argued that there was no need for them to give that advice in circumstances where they had already indicated their intention to end the contract. The court agreed. The court said, "It is well settled that the court may have regard to reports of law reform bodies to ascertain the mischief which a statute is intended to cure." Moreover, the modern approach to statutory interpretation insists that the context be considered in the first instance, not merely at some later stage when ambiguity might be thought to arise, and B, uses context in its widest sense to include such things as the existing state of the law and the mischief which one may discern the statute was intended to remedy. The context in this case was an arrangement of insurance which in normal circumstances would be ongoing, not a situation where the insurer had already advised of its intention to end the policy. From this case, we confirm that when interpreting statute, a court should be aware of the context and purpose of the statute at all times.